359.
I'll go over
As
why.
opposed to 358.
385.
That's the 358. Okay, that's 359.
Yeah, I have 359, including July 12th of last year. So today.
Consecutive language, but only ready to goes on count two.
Correct.
And we do, prosecutors, have the correct language for rating toes, don't we?
So,
No, no, no. No, no,
that was a
no. No,
statement.
no, no. This is not, and I think so. This is a have the
I mean,
correct
it's the language
language.
that I use on prior cases.
You know, there's other judges who don't care if things are right. I happen to care. Hey, simmer down there.
It is.
So,
Language is
so,
like,
all right.
I do it on paper and definitely sentence.
Hey, yeah, are you doing it online or on paper? Did you do it online?
Yeah.
Okay, you go ahead and do it online, because I just couldn't see it, you can't open it. You can't open
I
it?
can open it, I just couldn't save the signature.
Well. Anyway, Wolfgang, can you step up here a minute, please? Everybody ready? This is 22 CR 3226, State of Ohio versus Gerson Fuentes, counsel, please enter.
Dan Meyer, Dan Leonard, on behalf of the state of Ohio. Does that hold that Mr. Fuentes succeeded my last? Yes.
Mr. Myers?
Thank you, Your Honor.
Oh, wait.
Mr. Fuentes was originally indicted with 2 counts of rape in violation of Revised Code Section 2907.02A1B. Both counts specify that the victim was a child under the age of 10. Both counts were felonies of the first degree. He entered a general plea of not guilty to his arraignment. The state's understanding he now wishes to withdraw his previously entered general plea of not guilty and now plead guilty to count 1 as indicted for rape in violation of 2907.02A1B. The specification of a child under the age of 10, felony first degree. And that's count 2 to the amended offense of rape in violation of 2907.02A2 as a felony first degree. Count 1 carries the maximum potential sentence of either life with possibility of parole after 15 years or life without parole. count 2, the maximum sentence is an indefinite sentence having a minimum of 11 years and a maximum of 16 and a half years. The defendant will be required to register as a Tier 3 sex offender. All registration requirements, including residency restrictions, will apply to this defendant. There's a joint recommendation that he be sentenced on count 1 to life with the possibility of parole after 15 years. And that's count 2, a maximum sentence having an indefinite sentence of a minimum of 10 years and a maximum of 15 years. For a total of life with the possibility of parole after 25 to 30 years. Counts 1 and 2 are both mandatory prison terms. If he is released, there will be a mandatory 5 years post-release control. There's a possible fine of up to $20,000. And it is noted on the plea form that Mr. Fuentes is not a citizen of the United States. With regards to the plea, I should note that the state has been in contact with the mother of the child, and that she is not objecting to this plea or to this resolution.
Counsel, can you guys just step up here for 1 second? Mr. Fuentes, did you sign these forms, sir?
Yes.
Did you read and understand and have your attorney explain them to you before you signed them?
Yes.
So you know when you sign these forms, you're changing your previously not guilty plea, and you're pleading to count 1 to rape the child under 10 with a maximum possible prison sentence of life without parole. Do you understand that?
Yes, I can understand.
And to count 2, which is an F1 rape with a maximum sentence as an indefinite sentence of 11 years minimum to a maximum of 16 and a half years. Do you understand if you end up in prison as a result of this plea? Once released from prison, you would have a mandatory 5 years supervision from the Adult Parole Authority of Ohio. If you would violate the law while under their supervision, they can send you back to prison for more time on this case than this court would give you. But in any event, no more extra time that amount equal to 1/2 this court sentence, unless your violation constitutes a felony. Then you may be indicted, convicted, and sentenced on that new felony. The court in that new felony case may terminate the term of post-release control. In this case, with no further sanction. The court in that new felony case may sentence you to 12 months in prison or the amount of time left on post-release control, which is ever greater, or that court in that new felony case may give you a term of community control to be served consecutively or currently to the new felony. Do you understand that?
Yes.
Do you understand any fines, court costs, or restitution ordered would be a civil judgment for collection purposes?
Yes.
Do you understand you give up your right to go to trial when you enter a guilty plea?
Yes.
If you were to go to trial, the state would have to prove you guilty of these charges to a standard beyond reasonable doubt of every element that makes up the charge.
Yes.
You would have the right to have a jury of 12 persons hear and decide the case, render a unanimous verdict, or you could waive the jury and have the judge perform that function without the jury.
Yes.
In either event, you would have the right to be represented by counsel, have him cross-examine any of the witnesses the state brings to testify against you, as you have a constitutional right to see those witnesses face-to-face in the courtroom as they testify. You would have the right to have your witnesses, should you have any, subpoenaed to the stand. You would have the right to take the stand, testify in your own defense, or you could waive that right and remain silent during the trial. If there was a finding of guilt by way of trial, you would have the right to appeal that to the Court of Appeals with the assistance of counsel. These are a rendition of your rights as a defendant in this case. Do you understand them?
Yes.
Do you understand you're waiving these rights when you enter this guilty plea?
Yes.
I'm willing to have a trial, folks, just so everybody knows. Are you a citizen of the United States?
No.
Do you understand if you are not a citizen of the United States, that the conviction of the offense to which you are pleading guilty may have the consequence of deportation, exclusion from the admission to the United States, or denial of naturalization pursuant to the laws of the United States?
Yes.
Facts, please.
Thank you, Your Honor. This incident was first reported back on June 22nd of 2022. On that date, a referral was made to the Franklin County Children's Services, indicating that the minor victim, whose initials HN, who was 10 years old, had recently been seen by her primary care physician for parental concerns of fatigue. The physician determined a pregnancy test was necessary due to the symptoms and complaints being made, and that pregnancy test was ultimately positive, so the incident was reported. The case was assigned to a detective with the Columbus Police Department. The next day, the minor child was seen at the Center for Family Safety and Healing here in town. for a medical forensic interview.
Your Honor, I'm the interpreter.
Slow down.
I'm clearly hearing you.
Oh, you can't hear me? Let me come on the other side of the barrier. Where are you going to start from?
The pregnancy was positive.
Okay. There was a positive pregnancy test. On the following day, the minor child, along with her mother, went to the Center for Family Safety and Healing here in town. She participated in a medical forensic interview, but did not make any disclosure of sexual assault. On or about June 27th, the Columbus Police Department was made aware that the mother and her minor child had made the decision to abort the pregnancy. It was determined the gestational age on that time was around 6 weeks, 4 days. So with an estimated defense date sometime around May 12th of 2022. Ultimately, the mother and the minor child did travel to Indianapolis, Indiana, where a medical termination of the pregnancy was initiated on June 30th. On July 1st, the termination was completed. And then on July 2nd, members of the Columbus Police Department traveled to the hospital in Indianapolis to retrieve products of conception, that was what they would call, and then submit them as evidence for comparative DNA analysis. On July 6th of 2022, members of the Columbus Police Department went to the child's residence to obtain DNA samples from the minor child, as well as all males who were living in the home at the time, which included the defendant, Mr. Fuentes, who was the live-in boyfriend of the child's mother. These DNA samples were ultimately sent to the Columbus Police Crime Lab to be analyzed. On July 12th, the Columbus Police detectives initiated contact with Mr. Fuentes at his place of employment, and then asked him to come down to the headquarters to be interviewed. He once again provided a DNA swab, and then was interviewed about the incident. He waived his rights and chose to speak about the matter, and during the interview admitted to having vaginal intercourse on 2 separate times with the minor child. And then on July 15th, Columbus Police Crime Lab issued a report indicating that the preliminary results of that report, which has since been confirmed, is that Mr. Fuentes is the father of a child that was aborted in Indianapolis. The offense did occur in Franklin County, state of Ohio. At the time of the date of conception, the child was under the age of 10 years old at the time, Your Honor. May 28, 2012 specifically. Thank you.
Mr. Allen?
I have no exceptions, personally, please.
Anyone who's ever been in this courtroom for the last 20 years knows how this court feels about babies, young people being violated. However, today, by the request of the family, this court will be sentencing without comment. And everyone knows how hard that's going to be, because the court considers this the worst of the offense. But the family has asked for me to sentence without comment. The family has agreed to this, and this is a hard pill for this court to swallow, to take this joint recommendation. If that family hadn't begged me to take this joint recommendation, this would never be happening. Mr. Fuentes, you have been convicted of or pleaded guilty to a sexually oriented offense or a child victim offense, as defined in revised code 2950.01, and you are a tier 3 sex offender. You will have a lifetime of in-person verification every 90 days. Failure to register, failure to verify residence at the specified time, or failure to provide notice of change in resident address or other required information as described above will result in criminal prosecution. The joint recommendation of these parties is as follows. You will be sentenced to life in prison with the possibility of seeing the parole board after 25 years. Count one is life with possibility of parole after 15 years that will be consecutive to the maximum sentence, which is an indefinite sentence of a minimum of 11 years and a maximum of 16 and a half years for a total of life in prison with the possibility of parole, the possibility of parole in 25 years. 230. You are a tier 3 sex offender. Fines are waived. You have 359 days jail credit. That will be all. Oh, I'm sorry. Woo-hoo. I got a girl down here in a minute. The court finds that consecutive service is necessary to protect the public from future crime or to punish the offender, and that consecutive sentences are not disproportionate to the seriousness of the offender's conduct and to the danger the offender poses to the public. That'll be all.
Thank you, Your Honor.
Thank you.
I have a bunch of forms, I'm gonna get them.